Welcome back to another episode of Automotive Insiders. I'm your host, Jason Stein. Great to have you with us again. In today's episode, we're diving into one of the most pressing and costly challenges facing suppliers right now: the surge in litigation and disputes across the automotive supply chain. From rising costs and EV market volatility to aggressive contract enforcement and shifting legal precedents, the risks are real and they're growing. Our guest, Adam Ratliff of Warner Norcross Judd, helps us break down why disputes are increasing, how recent court decisions are reshaping contract negotiations, and what suppliers can do to protect themselves. Whether you're in the C-suite, procurement, legal, or sales, the insights here could help you avoid big mistakes that lead straight to the courtroom. It's a conversation every supplier should hear. It starts right now on Automotive Insiders. Adam, it's great to have you on the program. Thank you for being a guest.
Yeah, thanks, Jason. It's great to be here.
We're going to talk about the surge in supplier litigation and disputes that have come up over the last few years. And of course, it matters now because of cost and shifting supply chains and EV market uncertainty. But we want to analyze this from a couple different perspectives, and let's look at why we're seeing more disputes. What are some of the reasons that disputes are now popping up? And this is important because whether you're in the C-suite, legal, procurement, or sales, understanding that environment really can help avoid some costly mistakes. But I'll throw it over to you, Adam. Why are we seeing more of this now?
Yeah, thanks, Jason. I think you're right. It's an important thing for suppliers to be watching because suppliers are in the business of supplying products, not litigating cases. And even though that's what I do, we ultimately want to avoid litigation if you're a supplier. And so I think kind of following how it is that certain supply relationships end up in litigation is important. And it's a confluence of things right now. You mentioned, Jason, rising costs, pressures financially on the supply chain have led, what we've seen is a lot of suppliers and customers just to try to sometimes get out of older contracts, out of relationships. And sometimes there's a nice, clean way to do that. And that's always the preference. And that's what we like to try to guide our clients to. But other times there's not. And when push comes to shove, those disputes can end in litigation. And I think we've seen suppliers and customers get a little more aggressive and willing to push their disputes into litigation, into arbitration, for a couple of reasons. So first of all, we've seen since the Michigan Supreme Court's decision in 2023 in the Airbus case, it kind of gave the suppliers some new negotiating and litigating leverage. So, I could talk for a long time about that case, Jason. I'll save the dissertation for another forum. But I think, as a lot of suppliers have come to learn, the takeaway from that case is that these long-standing kind of blanket purchase orders that we know and have become accustomed to in the automotive industry, they might not always be enforceable by the customer to keep the supplier supplying. And in that case, the supplier was able to exit the relationship because it didn't get the price increase that it needed to cover rising costs. So that decision came out. It's been a little over 2 years now, and it doesn't apply to every supply relationship. We're not out there advising every single supplier to get out of your contract right away. But what it did is it allowed suppliers to take a critical look at their contracting documents. And what a lot of suppliers are finding is that some typical standard forms, typical standard provisions that we see out there a lot in the automotive industry are not necessarily enforceable. And so a supplier who is between a rock and a hard place due to rising costs, because they haven't had price relief, because it's a program that's been extended 3 or 4 times, and you're dealing with pre-COVID pricing, pre-material costs going up pricing, they've had to make the tough decision to tell their customers that, we don't think this is enforceable. We'd love to continue supplying you at a price that makes sense, but we can't do that indefinitely. And you can see how in a lot of situations, the customer's going to push back, and a lot of those cases have ended up in court.
Well, and so many other market factors going on too, right now, Adam. I mean, look at just EV market volatility, uncertainty around production volumes, delayed programs, shifting investments. Suppliers are all being forced to reevaluate long term commitments, right?
That's exactly right. And as suppliers have to think a little more critically about where they're going to put their capital, is it investing heavily in this potential new, what looks like it might be low volume EV program? Um, those decisions become a little more critical. And so a program miss, a pricing miss, where a program doesn't take off and the volumes are not what you expected as the supplier, can be that much more critical for a supplier. And it is, I think, to your point, pushing suppliers to perhaps be a little more aggressive where they need to be.
How about new legal developments that we need to watch, and that includes increase in warranty and some other activity, right?
Yeah, so that's another thing we've seen, Jason. I mean, some of this is pretty highly publicized. Some warranty issues that the big three have had recently. That's trickling down through the supply chain, and it's not necessarily ending up in lawsuits yet. I mean, you can think of several reasons why, OEMs might be a little more reticent to bring a lawsuit and make public all these issues. But there's all sorts of other things that we know in the supply base can happen when there's a field action, or the beginning of a warranty dispute before it ends up in court. And where we're seeing that come to fruition most often is aggressive debiting. We're seeing OEMs and even tier ones be a little more willing and aggressive to impose some pretty substantial debits down the supply chain, and that can have just as crushing of a financial impact on a supplier, especially if you're talking again a poorly priced or low volume program. A huge debit can just make it financially infeasible for a supplier to continue supplying.
How about some litigation or pending litigation, pending court cases in Michigan?
Yeah, so we had the Airboss case a couple years ago, and it was an important decision, but it didn't really say that much new about the law in Michigan. There had been, lawyers have been making the arguments that these contracts might not be enforceable before Airboss. But what we're really seeing now over the last 2 years is suppliers trying to apply that decision to other types of contracts that maybe weren't at issue in the Airboss case. But suppliers are pushing that same argument that I don't necessarily have a long-term supply agreement with my customer. So the big one we're seeing, Jason, is contracts that allow the customer a range or a flexibility of what they buy. When a supplier client comes to me with an issue or a customer, I want to get out of a contract, or I need to find a way to reprice my contract. This relationship isn't working for me. Where we always start is, well, what are you actually bound to do under your contract? Are you actually bound to continue supplying your customer at price X, or are you actually bound to continue purchasing from this supplier Y for the rest of the program if you want to make a move? And a lot of times the question right now, Jason, is, well, maybe. So there's a number of cases that are kind of percolating through both state courts, federal courts across the country, where courts are starting to apply the Airboss decision, and some are coming out and saying, yes, you can have this flexibility, customer, and you can sort of choose. Do you want to buy one part from this supplier, or you want to buy everything you need for the rest of the program? And other courts are taking a different view and saying, no, you have to say at the beginning of the relationship, I'm going to be with you, supplier, exclusively for this entire program. And if you don't say that, then you don't have an agreement. And because we have sort of these decisions that are coming down on both sides of the ledger, the issue is now teed back up in front of the Michigan Supreme Court in a couple cases that are pending and that could result in decisions as early as this fall.
There's also the issue of injunctions, battle of the forms, as it's known, conflicts between purchase orders, terms and conditions, and then warranty disputes. These are the hot litigation areas right now, right?
That's the other space where we're seeing a lot of action. Yep. So
Tell me about that.
yeah, the more litigation you have in the supply chain, it sort of goes hand in hand. The more likely you're to see these emergency type injunctions. So if a supplier, if there's a dispute and they're locking horns, the supplier and customer, the supplier's leverage is that they've got parts and they can withhold them. And oftentimes in that situation, the customer's leverage is their last piece of leverage is, well, we can go to court and get an injunction that forces you to continue supplying supplier. We've seen an uptick in these number of cases. I think you've had guests on here before, Jason, who have talked about Stellantis's willingness to file these types of cases against their suppliers. We've seen a number of other tier ones follow suit. Some repeat players who are willing to file these cases against their suppliers, and it's trickling down through the supply chain. And there's no one size fits all answer. Sometimes injunctions are granted, and sometimes they are not. It's very fact and court specific. And I think because there's no one size fits all answer, that's why we're continuing to see them being filed and parties taking that risk. You also mentioned battle of the forms. This one's not going away. This is something we've seen an increase in. I think as suppliers are getting more sophisticated in their contracting, their standard forms are becoming more robust. The lawyers are getting in there and adding fine print and fine language to these documents. And what I've seen, and we've seen some recent cases. I'm just talking the last couple of months from the Sixth Circuit and some other influential courts, federal courts and Michigan courts. And the takeaway I'd have for suppliers at this point is, don't think or just assume that a court is going to look at your contracting relationship and see it the same way you do. We've seen a willingness by some influential courts to look at forms going back and forth and saying, I'm sorry, I'm not going to assume that the purchase order governs, or that the price you were willing to quote supplier is the only price that you're willing to sell at. And sort of kind of throwing, I think, some supply relationships that the parties might have thought were pretty stable more into question. And those cases are not going away. And so, that's another reason to continue to be diligent about your contracting forms, because I think parties are getting more sophisticated across the board on that point.
So, final thing, you just alluded to it, be diligent with your contracting forms. What should suppliers be doing on a regular basis? I know you have kind of a 3-point plan here. What are those?
Yeah, so I think the first would be, I think you've had lawyers on this podcast say this before, but it can't hurt to say it again, Jason, right? Audit your supply chain. Know not just your contract documents. I mean, that's important. You got to know what they say. You got to know what your relationship actually is, what you're bound to do. But know your contracting partner. As we discussed at the top, with an increase in litigation, you can now look out there and say, I've got this request for quote from a great new customer. It's a line of business I'd love to be in, but is this a customer who sues their suppliers all the time? I mean, that's something to know. And I'm not saying, don't do business with that party, but just know what you're getting into, and know what's out there as far as court decisions about whether their terms are enforceable. Those are things you got to know, and you got to stay diligent. It's not just at the outset of the relationship. Watch for changing terms, new purchase orders coming across. We've seen an increase in attempts to sort of change the relationship midstream, and this is especially important, Jason, with respect to the court decisions we just talked about a minute ago. As the law changes, the sophisticated buyers out there are going to react to that. And if a court decision comes out and says, hey, your contract may not be enforceable, well, we've seen them try to fix that by issuing a quick purchase order adjustment that changes the terms. So have an eye out for that. So that's, know your contracts and continue to keep an eye on them would be one. Second would be going back to the beginning of your relationship. Be thoughtful when you're entering into new contracts. about what they say, and especially parties, I would say, that are doing so right now, know that the law might be about to change. A lot of provisions out there apply in Michigan law. We know that the Michigan law about what's enforceable and what's not enforceable might change in the next few months. So that's something you have to keep your eye on. And then lastly, I think if you fast forward to the end of a relationship, if things are really going south and you need to exit, you need to discuss the potential of an exit on either side of the relationship, just be thoughtful and strategic about it. I mean, it would be great if every supplier relationship that needs to wind down could wind down with a very friendly conversation, and there's a great last time buy that works for everyone, and everyone just goes their separate ways until the next program comes along. But unfortunately, we know that it's not always that way, and it can get ugly fast. You can end up in court pretty fast. And so our advice at that point is, you need to think strategically about how it could go south before sending that first letter, before saying that first thing to your supplier or customer. Talk to a lawyer. Think about the worst case scenario, and hopefully by doing so, you can avoid being one of these cases that end up in litigation that we talked about at the beginning of the podcast.
Those are the risks, the legal developments, and some proactive steps. We obviously encourage everybody to stay informed and to work closely with your legal advisors. Adam Ratliff, thank you so much for informing us and setting the table of kind of the things to look out for right now.
Yeah, thanks, Jason. I appreciate you having me.
Thanks again to my guest, Adam Ratliff, and thanks for listening to the program. You can hear more of Automotive Insiders on your favorite podcast platform or on the MEMA YouTube channel. I'm your host, Jason Stein. Thanks for being with us. We'll see you again next time.